Welcome to the Employment Law and HR Podcast with your host, Allison Colley.
Hello and welcome to this episode 156 of the Employment Law and HR Podcast. I'm your host, Allison Colley. I'm an employment solicitor and I run the firm Real Employment Law Advice, where we provide advice and assistance to employers and employees with all aspects of employment law. For those of you who are regular listeners, thank you very much for listening. And for those of you who are new, thank you very much for tuning in. I hope you find it helpful. You will know that I haven't actually uploaded a podcast for, it's about a month now. So I'm recording this on the 20th of September. So it will come out the week commencing the 21st of September 2020. And my last podcast was published on the 19th of August. Now, I think I probably mentioned in the last podcast that we were having a bit of a break. There have been a number of things going on, holidays and various personnel changes in the business, plus being super busy helping lots of organisations in relation to redundancy. We've also seen a spike in dealing with employment tribunal claims, both for individuals who are bringing the claims and for businesses. So it's been really busy and a lot going on, which has meant that I haven't got round to recording a podcast. So my apologies. I will get back to a regular schedule of podcasting, at least fortnightly, and I may bring you some updates and additional podcasts in between times, depending on what is going to happen next in relation to COVID-19. So as I said, I'm recording this on Sunday, the 20th of September, and all of the news reports, everything that's out at the moment suggests that there will be an announcement by the Prime Minister tomorrow, which may very well require an additional podcast pretty quickly after this, depending on what the announcement is. But it could be more restrictions on how we operate our businesses and how we go about our lives. So if there is, I'll bring you more updates and of course keep you up to date with everything you need. If you need anything in the meantime, or there's something that you want covered, or you have a question or a burning issue that you want to ask, then you can always give us a call in the office. There's myself, and I've got two colleagues who are qualified solicitors and who are experienced in employment law, who would be happy to answer your questions and help in any way that we can. We do offer an initial free telephone call, so you're very welcome to get in touch. The best number to call is the head office number, which is an Isle of Wight number, which is 01983 897 003. And that way we can direct you to one of the solicitors who's available. So rather a long intro from me, a bit unusual, but I thought I'd give you a bit of context as to where I've been, what's been going on and how we can help. So without further ado, I'm going to get into this week's featured content, which is a bit of an update and a recap in relation to self-isolation, sick pay and that kind of thing. So those of you who will recall way back to the beginning of March, when the whole coronavirus was on the horizon, people were talking about what happens if somebody is ill, how do you deal with it, all of those sorts of things. Well, obviously that didn't last very long. We didn't need to worry about that for too long, because actually we were all put into lockdown. And it kind of negated all of those questions that were arising about self-isolation and how do you pay someone and what do you do and how do you deal with it. But as businesses have all started to return, and many people are now returning to the office or various workplaces, and as more people are starting to develop symptoms or signs as we get into autumn, the return of school and all of those sorts of things, a number of questions have arisen about how you deal with employees who are self-isolating. So I thought I'd just do a quick recap on that, just by way of an update for employers. And hopefully this will be helpful for you. So according to the NHS website, which is the best place to go for direct information, up-to-date detail about what's going on in relation to testing and self-isolation. According to the NHS, somebody must self-isolate immediately if they have any symptoms of coronavirus. By now, hopefully you all understand what the symptoms are. namely high temperature, new cough, or continuous cough, should I say, or a loss or a change to sense of smell or taste. If they've tested positive for coronavirus, if they live with someone who has symptoms or who has tested positive, if someone in their support bubble has symptoms or has tested positive, so somebody they're exposed to regularly, if they're told to self-isolate by the NHS Trace and Test service, and also obviously if they arrive in the UK from a country which has the high coronavirus risk and they're ordered to self-isolate for that 14-day period. So those are the circumstances in which somebody who works for you or works with you may be required to self-isolate. And self-isolation means that they can't leave the house. So they can't go to work, they can't go to school, they can't go shopping, they can't do exercise. It really is staying at home for 14 days. Now, for those businesses and employers who can enable their employees to work from home, this shouldn't cause too many problems. However, if they are a parent to children of school age or younger, then it may be that some allowances need to be made in relation to the timing of their work. Because if they are required to self-isolate, then their household will be required to self-isolate, which means that their children won't be able to go to school or nursery, and they won't be able to access help or support from grandparents. So even though an employee may be able to work from home, you need to have consideration to the difficulties that it may present to having your family at home 24/7 for 14 days and how you're going to deal with that. If the employee can't work, so they're not able to work from home or they're not able to get into the office because of their self-isolating, obviously, then the coronavirus sick pay scheme will kick in. And what this means is that statutory sick pay becomes payable from the first day that they're absent from work if it is because they have coronavirus, they have coronavirus symptoms, someone in their house has the symptoms, they've been advised to stay at home by their doctor because of an underlying health condition, they've been told to self-isolate by a doctor or NHS 111, or they've been told to self-isolate by the Test and Trace service. So in those circumstances, they are eligible for statutory sick pay from day one of their absence. And under that scheme, you may recall it was introduced back in the early days of the coronavirus in the UK. Employers, or some employers, depending on how many employees you have and what NI you pay, can claim back up to 2 weeks of that statutory sick pay if they've paid it because of coronavirus. Now, you may recall that it was brought in to ensure that employers and employees complied with the requirements to self-isolate and didn't feel the need to work or to require their employees to return to work early because of financial reasons. So in essence, what happens if an employee who cannot work from home has coronavirus symptoms, then they are required to self-isolate immediately and they would be entitled to statutory sick pay from day one. Now, what should be happening is that if somebody has coronavirus symptoms, they should be given an opportunity to have a test, and then depending on the outcome of the test, if it's positive, obviously then they would still be required to self-isolate. And I understand that if the test is negative, then they are being told, although I haven't experienced this myself, nor does anybody I know directly, if it's negative, then they are told that they can return to normal life and they don't have to self-isolate, or in some circumstances they might be required to self-isolate. So they have to take the advice of the NHS once they have taken the test, depending on the result. But either way, from the first day of their absence, for coronavirus related reasons, they're entitled to statutory sick pay and you can then recover that as the employer. Now, a number of employers that I have spoken to are providing enhanced sick pay for those people who have to self-isolate, obviously recognising the difficulty that this can cause and trying to encourage employees to report symptoms and to be honest and to self-isolate as they should. Now, I appreciate that many employers can't afford to do this, but it is something that you need to consider. How are you going to pay employees? Are you going to pay them for the first couple of days until they get their test? assuming they're able to get a test, obviously? Or are you going to just say, right, statutory sick pay from day one? The reason why I bring this up is because, as I said, it may be that employees who are in financial hardship don't report that they have symptoms or don't even try to get a test because they're worried about the impact on their finances or their financial situation. And that could cause difficulties for your organisation or your business across the board. If somebody who is worried that they'll be put on statutory sick pay for self-isolating, even until they have a test, a couple of days, then decides to come into work, they could then obviously spread the coronavirus amongst your workforce and cause a much wider impact on your business. So it is weighing up the costs, but I think weighing up the costs versus the potential risk to your business or organisation if somebody doesn't tell you honestly that they have symptoms to avoid a financial hardship. And then this brings me on to what has been reported by the BBC and a number of other websites over the weekend, and I expect more detail next week. And that is, it's reported that employers are now going to have a penalty if they encourage employees to work or to attend work, should I say, when they have coronavirus, or in any way, shape or form kind of punish employees for self-isolating. So again, it's kind of putting that onus on employers to behave reasonably and ensure that employees feel safe to be honest if they do have coronavirus symptoms. I'm sure more detail will follow, but certainly the penalties for individuals who don't self-isolate when they should are going to be increased, and I think there will be a follow-on penalty for employers, but I'm not sure yet how that will look or who's responsible for policing it or enforcing it or how you go about reporting it. But as soon as I have more information, I will of course let you know. So just to summarise, it's important as a business or organisation that you have a strategy for how you're going to deal with paying employees if they have to self-isolate because they have coronavirus symptoms. And then you need to communicate that to your workforce wherever possible. For those of you who listen to the podcast regularly, you'll remember that I talked about right back at the beginning, looking at alternatives. So if an employee cannot undertake their normal job role from home and they're required to self-isolate, is there something else that you can get them to do that can increase productivity for your business or add value in some way, which will enable them to continue doing some form of work whilst they're self-isolating and enable you to then pay them for that time? So do try to think outside of the box. Do you have any admin tasks that they could undertake from home? Is there something that they can readily do? Now, I appreciate that that's not always the case with every business, but certainly, if you just stick rigidly to their job role and don't think out of the box, then you might find yourself over the course of the winter having a number of people who are out of the organisation, who are unproductive and basically sitting at home waiting out the time. So why not utilise that time for your business in a way that could help you to grow or move forward, or at least to maintain some form of status quo? The second thing I wanted to talk about very briefly is the job retention bonus scheme. Now, this is something that was announced back in, I think it was the end of July, and that is to say that any employer who retains an employee who was previously furloughed until the end of January 2021 will be entitled to a one-off payment of £1,000 for every employee that they have retained. So the idea being that employers are encouraged to keep as many employees on as possible who they may have furloughed during lockdown and during the furlough period. Of course, we know that you can't furlough anyone new now, and the furlough scheme is actually ending on the 31st of October. But if you have employees who are furloughed and they remain employed with you up until the 31st of January 2021, and they earned at least £520 a month on average between the 1st of November 2020 and the 31st of January 2021, then you'll be able to claim the bonus of £1,000 after you have filed your PAYE for January, and the payments will be made to you in February 2021. So it's quite a helpful scheme there. Although I do know from talking to a number of businesses, it hasn't actually impacted their decision making in relation to redundancies and that sort of thing. The £1,000 will be seen as being very good and very welcome, I'm sure, in February, but for many it hasn't impacted on their decision to make redundancies because they need to make the cutbacks now, and it's not realistic to keep employees on throughout November, December and January without having that work for them. And certainly many people are saying, well, my payroll for them for those months will far exceed the bonus I'm going to receive, and it's much better to deal with it whilst the job retention scheme is available. So I know a lot of employers have been making decisions, making redundancies and utilising the job retention scheme in relation to notice periods and that sort of thing. So it's something to look out for, and I'll put a link in the show notes to the guidance on the .gov.uk website, and that tells you a bit more about it and then what you need to do in relation to how to make the claim. Which currently it says, I should note that more detail will be available about the process at the end of September 2020. So expect more information about how you actually do it, but of course you won't be able to start dealing with any claims or the process until January anyway. Finally, just before I sign off, I do want to just touch upon redundancies and the redundancy process. Now, we are going to be in the week commencing 21st of September, which means that there are about 5 to 6 weeks, I haven't got a calendar in front of me, left of the job retention scheme. It ends at the 31st of October. So if you are looking at making reductions within your workforce, or you think you're not going to be able to bring people back at the end of furlough, then now is the time to start thinking about your consultation process and how you're going to go about doing that. If you're not going to be able to return someone to the workplace at the end of October, and you're not going to be able to pay them after that, if they're contracted with you and you have a contractual obligation to provide them with work and pay, then you'll need to address that with them. If you're going to be reducing hours, reducing pay, changing terms and conditions, anything like that, you need to start the consultation process ASAP. Don't wait until the scheme ends. Don't wait and hope that there is an extension to the scheme. You need to be proactive and think about what's going to happen post the 31st of October with those employees. Now, most employers I've been speaking to have brought the majority of their staff back in one form or another. So they are either doing flexi furlough or back full time. If, however, you haven't got staff back from furlough at all and you don't anticipate doing it, or you're looking at bringing them back flexibly, but you're not sure if you can maintain the full-time employment post the 31st of October, it's really important that you get some advice and you look into that as soon as possible. We do have a DIY redundancy product available on our website, which is realemploymentalradvice.co.uk/DIY-documents, where you'll find a redundancy pack with all of the information and documentation you need to run a redundancy process, either a simplified process where you have less than 20 staff at risk of redundancy, or a collective consultation process where there are more than 20. It's very reasonably priced, and hopefully you'll find everything you need in there to get the process started. And as I said at the beginning of the show, if you do have any questions or you want to run anything past us, then we're very happy to chat to you. Again, the telephone number you need is 01983 897 003. Or if you prefer to send an email, my email address is alison@realemploymentalradvice.co.uk. Just before I wrap up this week's episode of the podcast, I know that a number of HR professionals and other employment solicitors listen to this podcast, and I am currently looking to recruit an employment solicitor to work at our office on the Isle of Wight. Now, we have a number of solicitors who work remotely around the UK, but we do have a vacancy for somebody who would like to be based on the Isle of Wight. Now, I appreciate that moving to the Isle of Wight may be a big thing for you, but if it is something that you've been thinking about, or you know anyone who has any experience in employment law, but is also a qualified solicitor, you have to be qualified and have finished your training. But any level of employment experience, I'm very happy to train you, and you're happy to relocate to the sunny Isle of Wight, which is very sunny at the moment and very warm, then please do get in touch. Again, my email is alison@realemploymentlawadvice.co.uk. Many thanks for listening, and I hope you have a fantastic week, whatever may happen in relation to lockdowns, local lockdowns, or any further restrictions we have. Just remember, stay positive. We will come out of this in the end, and we are always stronger when we work together. Thanks again for listening. Just want to finalise by saying I wouldn't be a lawyer unless I had a legal disclaimer. So I must just say to you that the information in this podcast is for information only. It's general review and a general update. It's always necessary to get specific legal advice about your circumstances. So please don't rely on anything that you've heard in this podcast. But please do feel free to contact me if you'd like further information or specific advice.